Hello and good evening. So who's speaking here? My name is Thomas. I'm Executive Director of Epicenter Works. We are a Vienna-based digital rights organization that has been working on EU digital policy for the past 15 years. And if you want to learn more about us, we also have a booth on the second floor. And I'm here with Ralph today.
Yeah, my name is Ralph Bendrath. I'm working for the Greens in the European Parliament. And for me, this is personal. Because the picture here on the right, that's my laptop. 10 years ago, I was working for the chief negotiator in the European Parliament, Jan-Philipp Albrecht, on the General Data Protection Regulation. This is from the last negotiation round, almost exactly 10 years ago. Thanks for that. So now the Commission is proposing to reopen and weaken it. And not just the data protection regulation, but also some other digital rights laws we adopted in the last decade. So again, for me, this is personal, but we hope we can also get your enthusiasm about this.
Yeah, hopefully at the end it will be personal to everyone here. But let's start at the beginning. What even is an omnibus and why do we have to talk about it? And yes, at the beginning, this all has to do something with horse carriages that can carry everyone. That's where the name comes from, omnibus. It carries everyone. But in EU lawmaking, which is sadly the thing that brought us here together, we talk about omnibus laws, which are often a diverse collection of unrelated topics mixed in one package that's then voted en bloc with a single vote. That's for the theory, but now there's a more specific background.
Yeah, how did we get here? It started with this guy, Mario Draghi, former director of the European Central Bank, because, as you may have noticed, the European economy is not doing so well recently. Several reasons, of course, the COVID pandemic, the Ukraine war with raised energy prices, competition from the US and China and so on, think of electric cars or so. So the EU Commission wanted some ideas on how to get out of this crisis, and in 2023 asked this guy, Mario Draghi, to write a report with recommendations. And this report on the future of European competitiveness was published in September 2024. So please remember, the initial report was about competitiveness, how to make European companies more competitive against companies from the US or China or elsewhere.
And so all of this led to this simplification agenda, which will keep us busy for this European term. The 5-year legislative term will be mostly filled with these 17 simplification laws, 13 of which are omnibuses, so these big horse carriages with everything mixed together. Just to illustrate, the first 12 have been already proposed. We know what's going to be in them. Only the first one on sustainability has been adopted yet. And the first one you might know, it's the Due Diligence Directive, or in German, Lieferkettengesetz. So what's proposed? What's in these laws? They concern, for example, child labor. If you have that in your supply chains, don't worry, you're not liable anymore. If science finds that your pesticides that you're selling as Monsanto are causing cancer, don't worry, they can stay on the farms and on the fields in Europe for years. If we have new safety features for cars, and they should become mandatory, let's wait 10 years before we actually force industry to adopt them. And if you want to sell dirty combustion engine cars, don't worry, you can still do so because we are renegotiating the end for combustion cars. This whole agenda can be summed up as the wish list of the European People's Party, the Conservatives. Everything they did not get in the past decade in terms of progressive agenda, they are trying to get now with the new right-wing majority in the European Parliament. And that, of course, has led to a huge coalition from civil society, ranging from unions, labor rights organizations, environmental and digital rights NGOs, the Law Enforcement Union of Lithuania, and even the European Beekeepers Associations. So this is all really broad. And the narrative that we can use is that all of the protections that protect our rights, that protect our livelihoods, our health, our environment, they are now reframed as red tape, and that red tape needs to be cut in order to be competitive.
So we will focus on the two highlighted omnibuses, which risk, or according to the Commission, aim at watering down the digital rulebook we have adopted roughly in the last decade. There will also come next year a so-called digital fitness check, so there might be even more simplification proposals coming up to be seen. And I said, note that the initial report by Mario Draghi was about competitiveness. Okay, we can discuss that. Maybe some things are lacking in terms of competitiveness in Europe. But now the whole agenda and the whole Omnibus packages are discussed under the label simplification. And for some reason, they even now openly confess this is about deregulation. And deregulation means taking away regulations we adopted over the last 10 years to protect our rights. That's what they are for, you know, the General Data Protection Regulation, for example. And Ursula von der Leyen is really openly saying this.
Because when we look at simplification, we all agree we need simplification, we need deregulation.
She said it.
But not just Ursula von der Leyen, this is Svenja Hahn from the German Liberals, FDP, a member of the European Parliament, who published an op-ed in the Frankfurter Allgemeine Zeitung in November. Very open.
Yeah, and so you have to ask yourself, is there democratic backing for what the Commission is proposing? And no, there's not. 2/3 of Europeans are actually in favor of strong enforcement of our European laws against big tech, even if this would harm the relationships with President Donald Trump. So we will touch again on the strategic implications of all of this. There, of course, are geopolitical dimensions in play here, but it's very important to say that in 3 of the most populated countries in Europe, there is no political mandate for this reform. But let's look at the impacts. So what will the digital acquis, the digital omnibuses actually do for us, and why should they matter?
So on data protection, they are both of the highlighted omnibuses we showed earlier affect the General Data Protection Regulation. The first one is the so-called small mid-caps omnibus that was presented in May 2025 this year. And I don't know if anybody of you has ever heard of the word small mid-caps. For me, it's basically a new invention by the European Commission, which is a category of companies that are larger than the traditional SMEs, small and medium-sized enterprises, but not too large. So the proposal is now between 250 and 749 employees, and with a maximum annual turnover of 150 million euros per year. Discussion on the threshold is still open. In the parliament, some people are now even proposing to go up to 1,500 employees. And then you ask yourself, what is still beyond this, you know? And just as a reminder, when WhatsApp was bought by Meta for $1 billion with hundreds of millions of user data, it had 55 employees, you know? So again, this was already proposed in May, so we already in the parliament where I work, we had the deadline for tabling amendments. We did that, and we're now trying to at least convince colleagues, including from the Conservatives, that we should really make a distinction between different categories of companies. If it's a road construction company that only processes their employees' data, 500 employees maybe, to pay the salaries once a month, I couldn't care less. But if it's a company where the core business model is data processing, that could be a hell of a lot of data, you know? And they maybe should even at least have a record of their processing activities, because that's what it's about. The Commission is proposing that those companies, the small mid-caps, do not even have to know what they're doing in terms of data processing. So far, under the GDPR, every company has to at least have a record of their processing activities. That can be for a small sports club, it can be a list of 2 or 3 bullet points maybe. For companies, maybe a bit more, but it's just a foundation that you know what you're doing when you process personal data, because that also will help you to comply with all the other rules, and also comply with data subject access requests and stuff like that. And the Commission will now scrap that for small mid-caps, up to 750 employees. And again, we're trying to say, but if its core business is data processing, maybe it makes sense to still have that obligation to be seen. So that's ongoing already. And the second is the big so-called 7th omnibus, which they also call the Digital Simplification Package, which came on 19th November. It's 2 different laws. One is amending the General Data Protection Regulation, the Data Act, the Data Governance Act, the Open Data Directive, and the Network and Information Security Directive. Some in Brussels already call it the big, beautiful data bill, as a tongue-in-cheek reference to Donald Trump's big, beautiful bill on tax reduction from June. And the other one, the second one, is on simplifying basically the Artificial Intelligence Act. So on data protection, they're really not doing some technical simplification and lifting some rules here and making some rules easier to apply or whatever. They're going at the core of data protection law, which is the definition of what is personal data. Because if you change that and some data suddenly is not considered personal data anymore, you're out. The whole law doesn't apply to you anymore. And that's crazy. And the definition in the GDPR is actually quite clear. It says it's any information relating to an identified or identifiable natural person, in brackets data subject. An identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, and so on. And then the question was also back then, what is identify? Directly or indirectly or whatever. We try to clarify that in a recital 26, Erwägungsgrund in German, where we said to determine whether a natural person is identifiable, account should be taken of all the means reasonably likely to be used, such as singling out, either by the controller or by any other person, and so on. So the Commission is now proposing to add to the definition of personal data these sentences here, where they say information relating to a natural person is not necessarily personal data for every other person or entity, merely because someone else can identify that natural person. And such information does not become personal for that entity merely because a potential subsequent recipient, like further down in the supply chain, has means reasonably likely to be used to identify. So for some, it would be personal data, but for some others, maybe in the same supply chain, the same processing ecosystem, it would be considered not personal data, and the whole data protection law would not apply to them anymore. The Commission is claiming that this is based on a decision, a judgment from the European Court of Justice, just from this September, the so-called SRB, Single Resolution Board judgment. But that was a very, very specific case where the Single Resolution Board handed data over to Deloitte for further analysis and so on. But that wasn't even data about individual users, it was data about comments submitted by users. And the identifiers, as far as I understood it, were linked to the comments, not to the individuals. So, and then the court said this data is anonymous for Deloitte, but not for the Single Resolution Board. Okay, but to take this out of context and just this little piece of that judgment and make it in a general law is just a bit crazy. Also, if you consider that there have been other judgments in the past by the European Court of Justice, which also said what is personal data. For example, the Breyer judgment, yes, our Patrick Breyer, where the court said IP addresses are personal data, even for if you're not the internet access provider, but just some website. Or the Scania case, where the court said vehicle identification numbers are personal data, even if Scania does not know which user has which number, but the registration authorities do so. And the important thing here is, again, the singling out. And we discussed that in depth when we negotiated the GDPR 10 years ago, including with the back then European Data Protection Supervisor, Peter Hustings, in 2013 even, I think, or 12.
What is the difference between identification and singling out? If you can say, I can see data of Oyster card holders on the London Underground who hold on these prepayment cards, and I can single out the fact that passenger A is distinct from passenger B. So I can single out that there are lots of different people, but I can't identify any of them.
Now, in real life, in a classroom, the boy with the dark hair, curls, and the blue trouser, please leave the room. Then everybody knows who it is. This singling out refers to the capacity of providers on the internet. They are able to use the well-known attributes of this single user by nudging someone into behavior. that's effective advertising. They say, we don't know who this is. It's anonymous. No. The point is, it is personal data, without any doubt. And that message is, of course, not very welcome for some big stakeholders.
That's from the movie Democracy im Rausch der Daten, this nice documentary. Thanks to that, I've got an Internet Movie Database entry, actually. But it even gets worse. The Commission is now also proposing to introduce a new Article 41A, which would give them the power to decide under which circumstances pseudonymized data is anonymous data for certain parties, and not pseudonymized, because pseudonymized data is still personal data. That's also very clear in the GDPR. And now they want to give themselves, the Commission, the power by implementing acts to make this, to clarify where the border lies, which is already crazy under EU primary law, because under the treaties, implementing acts are really just technical implementations. They must not change the core of the law, you know. Just crazy. But that's what they are, what they're doing. And now another definition thingy, where the Commission now proposes a new definition of scientific research. Because in the GDPR already, we said back then, if you have data collected already, you can use it. Technically, it's for a different purpose, but if that different purpose is scientific research, then we think it's okay. If you have that data already, you can do statistics and whatever. But now they put this definition of scientific research here on the table, which is any research which can also support innovation or even apply existing knowledge in novel ways. So you don't even produce new knowledge, what I would consider being research. You just take existing knowledge and apply it somewhere else. You know? And of course, they also clarify openly that this is also may further commercial interest, completely ignoring the standard elements of scientific research. I mean, I have an academic background. I did academic research for 10 years after I graduated. Peer review of research results, publication of research results, and all that is considered scientific research in my world, you know. But this basically is all a gift to the AI bros, you know. That's what's behind it. They want to make all data available for AI companies, and they call it research when they train their LLM, and then that's it. And in fact, they even have a new Article 88C they propose for the GDPR now, which basically says training artificial intelligence systems with personal data is in your legitimate interest. And for those who don't know the GDPR by heart, I mean, who wouldn't? You need, when you want to process personal data, you need a legal basis for that under the GDPR. It can be a legal obligation, it can be a contractual agreement, it can be by the consent of the person concerned, or it can also be possible if you claim that the processing is in your legitimate interest. And here they say training AI with personal data is in the legitimate interest, which is already funny because AI is just a technology. It's not a like social or economic or whatever purpose, it's applying a technology. You could also say using blockchain with personal data is in your legitimate interest. Why? But on the other hand, I mean, if they want to openly say you can take personal data without the person's consent, and train AI with that, they should openly say it, but they already even say, yeah, but still the safeguards we have in Article 6, GDPR on legitimate interest still apply, so if the person's rights and interests override your legitimate interest, then you cannot do it. Which is, I'm not sure if that's even simplification. I'm not sure if that is enhancing competitiveness of European companies, but it's certainly not simplification. And they still don't deal with all the other problems we have with AI and personal data because all my other data subject rights still apply. My right to have my data corrected, for example. When ChatGPT came on the market, I think 3 years ago, right? I asked it, who is Ralf Bendrath? And ChatGPT, back then GPT-3 said, Ralf Bendrath is a professor for data protection at the Technical University of Darmstadt. I've never worked in Darmstadt. So technically, I have a right to have that data corrected under the GDPR. But how do they want to do that? There's no like database entry under the name of Ralf Bendrath where they put a new corrected content in. That all that information is like in the statistical white noise in the AI system, you know? And they still wouldn't know how to deal with that. So it's trying to get something for the AI bros, but still not really clarifying anything. So the worst of both worlds, you could argue. And then if you look at surveys, Neub recently did one, and it turned out that only 7% of Meta's users, in this case, want Meta to use their personal data for AI training. But the Commission, for some reason, I mean, they have this whole AI, artificial intelligence agenda. They complain that only 10% of small, medium companies are using AI, and that needs to go up to 50%, and we need to do something about it. They're still on this hype curve. It's crazy, but so this is basically where we are at the moment. And the challenge is, of course, how to rescue the child here in the front. So, but then it even gets worse. The Commission is also now saying, if you exercise your rights you have under the GDPR, for example, the right to get access to my data that somebody else has stored about me, that can be refused if I abuse that right. So how can rights, if I exercise a right, a fundamental right, how can that be abuse at all? And they say, yeah, but there's a lot of people who just ask for their data over and over again, and it's just annoying, it's getting on the nerves of the companies, and it costs time and stuff. Okay, maybe we can do what's the English term? Rate limitation. You can only ask twice per year or whatever, I don't know. I'm open to discuss that. But this abuse is really crazy. And I mean, this right has been used by, let's say, labor unions, where people then send a data subject request to their employers to find out how many overhours they had. And of course, that the purpose of that was not to protect my personal data, because the GDPR is not about protecting data, it's about protecting natural persons in the context of processing their personal data. And of course, the interest was behind that was a gainful interest. They wanted to be compensated for the overhours, fair enough, you know. And now the Commission would say this is abuse. Crazy, again. But there's still, I think the announcement of the talk said there might be, it might contain traces of hope.
Traces.
But there's some hope. Where we discussed this with people working in the Commission on this and preparing this before the summer break, we told them, if there's one thing where you could do simplification and everybody in Europe would love you, do something about the cookie banners. Because they're getting on everybody's nerves. Just a footnote, a reminder, the GDPR does not require any cookie banners. If you just process data that is necessary to show somebody a website or maybe to present an online shop or something, it's totally fine. The cookie banners are basically necessary if you want to collect more data and process it for other purposes and basically do real-time betting and selling it to data brokers. You know, that's when you need the cookie banners. But okay, if that can be made clearer that they are not okay, fine. So they now say every website would have to provide a one-click option for refusing consent. Okay? But there's exceptions, like for first-party audience measurement and security purposes, quite broad, but maybe we can fix that. But then they also say, if I refuse my consent, the website can only ask me again after 6 months. How does the website know when I've been there last time? They would have to process my personal data. You know, it's not thought through also. They had to do this in a big rush, apparently, this autumn. And then the other thing they propose in this context is that the do not track standard of the World Wide Web Consortium basically would be legally binding. So if my browser tells the website, don't track me, then that would be legally binding on the website. And they also say the browser manufacturers now would have an obligation to build in this functionality, which is still missing yet. Some things to fix there as well, but okay, this is the part that's going in the right direction, I think. There's some smaller things you can ask me later over a beer or so, but this is for the data protection part, and you see, I take this person. But over to Thomas again.
Yes, sadly, it's not only just the data protection stuff. There are also proposed amendments to the European Union's AI Act. It's a law that already was adopted and in part also comes into force step by step. One of the things that's in this AI Act is a clear prohibition. It's important to note that this law has a risk-based approach. So the strictest rules are on the most dangerous applications of AI. And there are even clearly prohibited systems. For example, emotional recognition in classrooms or at the workplace, social scoring, biometrical classifications, or predictive policing. The good news is these are clearly prohibited uses of AI, and they are already in effect. The bad news is, because of the debate that we are having right now, many member states have been dragging their feet and not even appointed the national regulators in charge of enforcing these bans. So that basically allows these extremely devastating and damaging systems to persist. What's the second category below the prohibited one? That's the high-risk AI use cases. Think about law enforcement, migrations and borders, general judicial system. And these high-risk systems, of course, have higher obligations to fulfill, and they should become enforceable by August of next year, of 2026. But the proposal asks to stop the clock on all of this for around 16 months. So that means all of these risk mitigation measures, the higher duties of care, the necessity to prevent bias in your data, and to really show that you have reckoned with the risk that you might cause with your systems, all of that is paused for 16 months. That means when a boss wants to use AI to fire people, they no longer have to consult with their work council. And this is already bad, but it gets worse because there is an additional loophole that comes into play, because we have a provision that would allow AI systems to remain on the market if they were introduced before these provisions come into effect. So you could basically now see a rush with these 16 months to establish risky AI system and in the European market and then hide them in a regulatory gray zone, making enforcement much more costly. Legal uncertainty would skyrocket. And just to give you one example why this matters, the facial recognition that was applied at the Pride in Budapest, this already happened once. This means without protections, this will happen again. And lastly, we also have already a very dirty deal that was struck around the AI Act. For these high-risk systems, you can actually escape your obligations when you believe that, no, I'm actually not high risk. I do not want to deal with these higher burdens. And you can escape your responsibility by registering yourself in a transparency database. So yeah, this company believes that this system is not actually high risk. That's already a dirty deal to escape these important provisions, but at least we have transparency. Regulators, civil society, academia, we could at least know who is using the dirty trick. But now, what is the regulatory simplification? We are removing even that patch on the pothole. So you do no longer have to at least give this transparency, that we would not simply never know which company is using this loophole. And again, think about competitiveness. This introduces a lot of risk in the European market, because if you are just implementing these AI systems, you no longer know whether they are high risk or not. So you suddenly share liability and responsibility that might affect your employees, your customers, your citizens, without even knowing that. So that's it for the AI Act. And then there's one other issue that we need to talk about, which is open data. This is a super big law, and we're just touching on the noteworthy stuff. There's also general simplifications that just we're leaving out here. For example, a lot of stuff that is non-personal data. Many laws are standardized into the so-called Data Act, and one of them is the Open Data Directive. But here's something that we need to discuss, because usually the Open Data Directive would oblige member states to publish all of their information under an open license. Any public sector information, think about open government data, needs to be there, openly available for everyone. But now this obligation to use standard licenses like Creative Commons is removed. And instead, there is a new obligation or possibility for public sector bodies to negotiate with big tech to be paid for giving that data. And this really touches on the paradox of open. Openness both challenges dominant platforms, but it can also entrench them even further. Very often you need scale, capital, infrastructure to even make use of this open data. And this paradox is now in the forefront of this debate. And the open definition that really underpins from open source to open culture everything has this clear anyone language, so anyone needs to be able to use that data. And what we are doing here, I don't know whether the Commission was aware or not, we are basically creating a huge split. Because any Creative Commons license, CC by SA, would be incompatible with this anyone but big tech new license. So you suddenly have a clash in the open universe, and that might have really unintended consequences. One potential way out actually is shown by Wikimedia. Wikimedia, they have the Wikimedia Enterprise API for many years already, which actually is a cash cow for the Wikimedia Foundation to make money out of these AI agents that are scraping the Wikipedia encyclopedia. And something like this, where we no longer touch the licensing, but really charge for the access, if you're doing it on a heavy load, might be a way out of this. And then lastly, it's not just what we touched upon so far, there are a few things on the horizon. The Digital Networks Act comes in January. That might include a repeal of net neutrality. That's, of course, a hugely important issue. We'll watch closely. And a lot of this will, again, lead to higher concentration on the telecom market, higher prices, and might even touch on regulatory independence. Thankfully, there was nothing in terms of digital identity in the IDAS. It's mostly harmless amendments. And as Ralph has mentioned, there will be a Digital Fairness Act, which is kind of an opening hole for many more reforms, maybe also of the Digital Services Act and Digital Markets Act, these two laws that Trump is always talking about. And then lastly, we are not even sure if these are all of the GDPR reforms that we will see. One side of the Commission says, that's it, we are not going to touch anything else. And the other side of the Commission says, we might actually do more. So let's look at that.
Yeah, that's actually also an internal fight taking place in the Commission. I heard from some people in the cabinets of the commissioners when this was all discussed before the release, that it was basically all the EPP, the Conservatives, commissioners against everybody else. And in the end, the Conservatives prevailed because of Ursula von der Leyen. But okay, this is of course all happening in the context of the larger picture, including outside Europe, the transatlantic tensions over regulating big tech. You might recall already last March at the Munich Security Conference, US Vice President J.D. Vance basically threatened to withdraw NATO security guarantees if the EU would enforce the Digital Services Act. And just a couple of weeks ago, US Trade Secretary Lutnick was in Brussels and offered the Commission to lower the tariffs on steel and aluminium in exchange for the EU softening its digital rulebook. And just recently, we had the first major DSA, Digital Services Act enforcement against X, where the Commission now is fining X with 120 million euros. But this is not even going after the very core, after the toxic algorithm that creates the feed on X now. But this was going against the fact that the blue check mark is suggesting that person has been authenticated, whereas the person just paid for it, you know. But even here, the US government, this is Foreign Secretary Marco Rubio, said this is an attack on the American people by foreign governments.
Yeah, so you might ask yourself, are these laws kind of align very well with the interest of these American tech companies? I wonder who was meeting with the Commission in drafting all of this. And thanks to the Corporate European Observatory sister organization, we actually know that the European Commission head of the Omnibuses was even sidestepping its own transparency rules by labeling meetings with big tech as mere technical in nature and trying to hide them from the transparency register. To give you an idea of what we are up against, on average, the big tech lobby meets with the European Commission once every workday. The total budget of big tech this year skyrocketed. It's been growing steadily, but now we are at 151 million euros just for 2025, and that's a conservative estimate. So this is just like all of this debate, keep that in mind. But there's another strategic implication that we need to talk about. When Europe adopted the GDPR, we were applauded worldwide for setting the gold standard on privacy. I would argue it's one of the things where Europe actually can be competitive with IT you can trust. rule of law, with a system where it's actually predictable what will happen with your data, where you can trust the institutions, where encryption is not touched, where the provider does not have to comply with a gag order and rant you out without telling you. All of that could be a strategic advantage. And when we adopted a GDPR, around 100 countries followed suit with adopting similar GDPR-inspired laws. Many of the definitions, for example, were adopted worldwide. And this map is even outdated because there have been more countries that have adopted this, but it was even coined with a special term, the Brussels effect. The effect that Brussels might not lead in the development of these software products or not really in the hardware manufacturing, but at least it's good at regulating and creating a safe regulatory framework that's then adopted worldwide. But that, of course, can no longer work if we are reverting ourselves, like we've seen in the UK.
Yeah, one element of this Brussels effect for the GDPR is the fact that transfers of personal data to countries outside of the EU are only allowed either if you take specific safeguards and have special contractual arrangements and all that, or if that country as a whole gets a rating from the EU Commission that the protection level there is adequate to our GDPR. Then the data can free flowly back and forth. That's the reason, basically, why so many other countries followed the GDPR model and adopted their own data protection laws. And now, the UK, for example, when they left the European Union, thanks to Brexit, they basically copied the GDPR into the British law books. And the British lawmakers are now questioning now, how can we still be adequate with a moving target, where we don't know with what we have to be adequate in the future. It's really ironic. Yeah, and so you already hear, I guess, that we are not super happy about this. But we're not the only ones. There's been a lot of criticism already when the first drafts of the digital omnibuses in November were leaked. So 3 pro-European political groups in the European Parliament sent immediately on the next day letters to the European Commission protesting these drafts and calling the Commission to not do these radical changes. From the Social Democrats, from the Liberals, and from my group, the Greens. And a week later, after the final official proposals were published, the European Parliament had a plenary debate on this. Of course, several different opinions, and some of them even want to go further and so on. Some are very critical. My money quote here, my favorite quote, is from Irish liberal Michael McNamara.
We do really need to avoid a Groucho Marx approach to regulation. These are my principles, but if you don't like them, I have others. These are our laws, but if you don't like them, we have others.
Yeah, it's really hard to take.
I wonder how many people are old enough to still remember Groucho Marx. Whatever.
Yeah, there's also, of course, more criticism from within the institutions. The EU watchdog, the EU Ombudsman Office, it's called, it's actually an ombudswoman, Teresa Nijo, criticized this whole omnibus agenda because there was no impact assessment. Because in the few consultations we had, they actually did not consult the changes they were going to propose. And she comes to the conclusion that this all amounts to maladministration by the Commission. And even within the European Commission, there is criticism. The College of Commissioners is the body of all of the 27 commissioners. And here the Executive Vice President, Teresa Ribera, she's actually the #1 behind Ursula von der Leyen and one of the few Social Democrats. She calls this whole exercise Trumpist and a terrible political spectacle. And the funny thing is her portfolio actually regards competitiveness, so she would be the one in charge. Also, of course, the consumer protection organizations are extremely pissed. They were also not consulted. Similarly, us as digital rights NGOs, we also sent our letter with 127 digital rights NGOs. And of course, the GDPR and the AI Act, as the changes are seen as devastating. And really, it's important to say that this is a bad faith attempt to deregulate. There would be meaningful changes to the GDPR that we can discuss. I think every law deserves a review after a decade, but not in that way, not with these intentions. So what shall we do? We mentioned that there will be traces of hope. Hopefully we can come to that. But first, what's the timeline?
Yeah, just quickly, where are we now? So again, on 19th November, these legislative proposals were presented. So in the European Parliament, by mid-end January, we will probably know who will be the lead negotiators. Again, it's two different files, the so-called data omnibus and the AI omnibus. Both of them will be dealt with in two committees, so it will be 4 members in 3 committees. And then we will see. We are still trying to get the rapporteur, the chief negotiator, again for the GDPR part, because we did it like 2 times already now, and people kind of trust us there, but to be seen. Then in the council, in the member states, it's a bit of an odd construction. They do it in a very fast-paced procedure. I hear from colleagues in the perm reps, but it's also normally, like things like the data protection regulation, they are discussed in the expert working party in council, the data protection working party. All the omnibuses, however, are discussed in the so-called anti-G simplification group. The anti-G are the assistants of the EU ambassadors from the member states. So they are generalists. They don't know shit about the details of the definition of personal data. They don't know details of AI Act or what have you, or licensing stuff. So it's really worrying on that front as well. And the AI Act Omnibus has a different timeline. They're even already discussing taking out only the stop the clock part, because that would have to be adopted before August next year. Yeah, and then we probably have a parliament position later next year to be seen. If we become rapporteur again, we will insist that there will be an alternative impact assessment by the Parliament Research Service, because the Commission didn't do any impact assessment. But to be seen. And then maybe early 2027 or so, the final agreement between Parliament and Member States will be there, or to be confirmed, but this is roughly the timeline. But if you want to be successful in Brussels, you have to be early.
Yes, that is really the most important factor. And the good news is that we are still early. This was just adopted, proposed on 19th of November. So there, although it's a speedy procedure, is enough time to do something. And the first step always is, we have to acknowledge that this is a problem. And we have to talk about, we have to really become aware that this might be one of the biggest fights that we have to face. We all know that the trend right now is going against progressive causes, going against human rights, going against any form of protective regulation, no matter if that's the environment or our data. And so really reckoning with the moment that we are in, and then first, inform yourself. This talk is a good start, but there are so many other things to read and to watch and organizations to follow. Do all of that, whatever follows your inclination. Get a trusted source and then share it with the group, with the resonance room that you are connected to, so that this actually can become an issue more people are informed about. This really is the first step and the precondition. Many organizations have put out great analysis. This talk is also based upon a lot of that. And so you do not have to do this research yourself, but find it and share it. That's already the first important step. And then secondly, contact your representative. I cannot stress this enough, and this has been proven over and over again. We can actually make a difference in Brussels if we start sending emails, if we pick up the phone, if we post on any social network that still exists to these lawmakers. Because since they are not attuned to this type of public attention, it actually has an impact. The website of the European Parliament is a great place to start. We've already created a free software called deregulation.eu that makes calling representatives very easy. It was actually used with the first Omnibus on due diligence, corporate sustainability, Lieferkettengesetz by Oxfam Germany. So this is all software that's available to make it easy. And I think we can also point to the recent chat control.
Yeah, I can cut it short. If you have been at the previous talk in Hall 1 on chat control, you know it already, how that works. If not, watch the recording, because chat control is one example where civil society pressure really made a difference.
Yeah, and then third, of course, support the NGOs working on this. And as you can see in the lower half here, this is going far beyond digital rights. This also concerns many other causes, and the NGOs working in that fields are important to support too. But it's super necessary these days, since the funding landscape is really devastating, since Open Society Foundation has evaporated in Europe and many other funders have left the space. Many of these organizations, in order to do their work independently, really rely on individual small donations. That's the only way to keep on doing this work, particularly independently, when you are facing such big adversaries. And my tip is always look at the past track records of an organization, and it's usually better to support the smaller organizations than the bigger ones. Yeah, then we're going to conclude with two things. First, this beautiful street action that was done on the day when the package dropped on the 19th of November. This is in front of the Parlement, the headquarters of the European Commission. Ursula, fight for Europe, not for them, not for the tech bros of Trump. This was done by People versus Big Tech and already gives you a great slogan. And then, of course, there is a workshop here at Congress on day 3 at 12:30 at Workshop Room D, where you can continue the discussion with us and thankfully organized by Digitale Gesellschaft. And we will all meet there to start organizing the defense. And with that, we're looking forward to your questions. Thank you very much.
Thank you very much, Ralph and Thomas, for this really interesting talk. I feel definitely better informed now, and I will also refer back to it, because for my job, a lot of these things will actually be relevant. Now, we do have some questions already. Let's start with microphone number 1.
Hey, thanks for this great talk and the great pictures for that, for still the serious topic that we have. We are in the second wave, I would say. The first, the sustainability part and the due diligence for supply chain, and we could say we have missed that bus already. What went wrong there, and why do we have a chance now?
Yeah, I think there's a strategic difference between certain omnibuses and other omnibuses. On the due diligence, for example, but also the end of the combustion engine and rules like that, those rules were adopted by a center-left majority in the European Parliament before the last elections, when we still could get majorities against EPP, against the Conservatives. This is gone now. Now we need the Conservatives to get a majority for anything slightly progressive even, and they can get a majority with the right-wing assholes and the fascists, against us and the liberals even. And this is what happened with the due diligence omnibus that was basically pushed through with the EPP towards fascists, right-wing majority. And Manfred Weber is becoming more open about this, that he wants to strategically not maybe cooperate, he wouldn't call it cooperate, but align the voting behavior with the far right. On data protection and also AI and others, I have a slightly more hope, because those laws were adopted also in the previous mandates, but with everybody on board. Not just EPP, but also ECR and the others. So there, people, and especially on my level, on the technical level, where most of the negotiations on the actual texts are done, are more or less aligned still. Of course, they're different, they have different mandates, and we would like to improve the GDPR even further. Some of them want to soften it a bit more. But my hope is that we can maybe get some reasonable result, and at least convince EPP colleagues that changing the definition of personal data is just not a good idea. You know, maybe keep the fingers off of that, and let's work on some more reasonable parts of the proposal. Same for the AI Act and the Data Act, maybe. I think the important strategic question here is on the framing. If this gets framed, like we had on the upload filters, copyright reform a couple of years ago, for example, if this is framed as a conflict between Greens, socialists against EPP, then we can only lose. If we frame it Europe against Donald Trump, then we at least have a chance. I told you, traces of hope.
Thank you.
Let's continue with microphone number 2.
All right, thank you both for your for your work and the talk you gave. I just wanted to ask if you can show the second last slide again about the sessions.
Oh.
Yeah, that one.
Yep.
Thanks.
I don't know, maybe Epunk and Tom can explain us if the session will be in German or English or both.
Yeah, both.
English, okay.
Both.
Both, good, good. Because the announcement is in German only.
Session will be in English. Good. That was an easy question. Let me check with the Signal Angel. Are there any questions from the internet?
There might be something like that. There was a question like, what companies or organizations already implemented something like liquid democracy on that planet in 21st century? I'm not sure what it means.
I'm also not sure. Like
liquid democracy? Yeah. Did I get that right? I only know liquid democracy from the Pirate Party.
Liquid democracy, yeah.
Yeah, I only know that from the Pirate Party. I'm not aware that any companies are actually applying this. And companies normally are not democratic entities. They are owned by somebody. Sorry, I don't know. I've never heard liquid democracy or anything related to, even slightly related to that in this reform agenda context.
All right, then. Let's continue with microphone number 3.
Thank you for this great talk. I was wondering, you showed the timeline, right, which is very tight. And so my basic question is, can they do that even? So like, to what extent is this legal? Thank you.
I mean, they can do it, but probably only poorly, definitely not with the necessary due diligence. And recently there have even been legal opinions saying that the way in which these omnibuses are done actually opens them up for judgments by the European Highest Court, because this is simply going against all of the rules of procedure, and these are not mere technical simplifications. So the whole legal instrument of doing this via an omnibus might be the wrong approach. So in a way, we are seeing first glimpse that this house of cards might collapse. The big question now is for Ursula von der Leyen at the European People's Party, why they are betting so much on that. I mean, this is also going to the core of legitimacy for the European Union. As I showed earlier, 2/3 of people want the EU, they need the EU to protect them against big tech. None of our national governments, not even the big countries, can do that on their own. And suddenly they are giving up on that. So one has to question if one of these meetings in the White House doesn't play a role in that.
Yeah, but I mean, to be fair, the Parliament, the European Ombudsperson, and also some legal experts have said this could lead to challenges at the European Court of Justice, but that was against the Commission's way of working, because they didn't do an impact assessment, they didn't consult on everything, including on the GDPR and stuff like that. So this goes really against the agreed rules on better lawmaking, better regulation. But once it's in our hands in the Parliament, it's up to the rapporteur and the negotiating team to decide on their calendar and how many meetings they want to have per month and all that, and how much they can squeeze into their calendars. I mean, when we negotiated the GDPR back in the day, 10 years ago, we also had like 2 political negotiations each week, because we wanted to finish under the Luxembourg presidency, because they were the greatest, and we did. So that's also a choice of prioritization. That cannot really be challenged in court, I would say. But again, no matter how long it will take, in the end, start early, to raise awareness, to make noise, and then maybe in the end with some campaign similar to chat control also, we can have some impact.
Microphone number 2, please.
Hi, thank you for your talk. It has been very disempowering to watch from the other side of the Atlantic as one of the only jurisdictions in the world that can stand up to US power fails to do so. Thank you for giving a lot of advice on how European citizens and residents can pressure their lawmakers, but here's 2 questions. What can people working in or with influence over US NGOs do at this point, if anything, to help? Even though we've failed clearly so far. Yeah. And the other is, as people operating outside of EU jurisdiction who can basically do whatever the fuck we want with European lawmakers' data as long as we can obtain it legally, is it useful to, for example, demonstrate some of these more difficult to understand concepts for non-technical audiences like reasonably re-identifiable or this kind of differential privacy definitions, this whole long course of Latanya Sweeney publications that very few people understand. Is it somehow useful for out of EU actors to help pressure EU lawmakers by direct demonstration of what these concepts mean and how their rights, like any European residents, will be violated if these laws go into effect?
Yeah.
Yes.
Yes, for both.
I think for the first question, if I may, on if you're from the US, what can you do in particular on the question of the definition of personal data? Maybe just send an email or a letter to European lawmakers and explain to them that the California Consumer Privacy Act has such a long checklist of what can be considered personal data, and now the Commission wants to do the European definition like this, just to make them understand that they should be embarrassed.
And there's the Brussels effect, and it has an accompanying California effect. So those two sometimes are in competition. But to the core of your question, I think it's extremely advisable to not just have the usual suspects voice the same criticism that everybody expects. We usually win when it comes from unlikely allies, when it comes from regions and groups and also ideologies that you would not expect to be part of that debate. So yes, doing that cross-sector, cross-Atlantic is extremely great. If we can have one big debate about these things, because I do believe that a lot of that is inspired by Trump and Doge and what's happening in the US. So the megatrends need to be talked about. And then the second thing, yes, visualizing the effects of this, and there is a lot in the surveillance advertisement business model that needs to be explained in the context of these reforms. NOIP, None of Your Business, the organization of Max Schrems, has done already a good job in legal language terms, but I think much more needs to be done in code, in visualization, to make people comprehend. And yes, lawmakers are great targets for these things too.
We can do one or two more questions. One has been waiting at microphone 1 for a while.
Thank you for the talk. You framed this as kind of external influence and macroeconomic drivers, and I was wondering how much of this could also be driven by sort of the European influences of data sovereignty arguments and needing to kind of restrict certain kinds of speech and sort of the kind of shrinking of the Section 230 kind of fair game.
Yeah, we had one slide in the preparation on the European Digital Sovereignty Summit that took place in Berlin on the day before these proposals were presented, with Emmanuel Macron attending and so on. But that we took it out because the whole summit was a joke. It was basically saying AI, 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 and simplification, simplification, simplification. And that's again why whenever you engage with decision makers here or policy makers or journalists or whoever, ask them, how would this help competitiveness of SMEs, small and medium companies in Europe, and not the big tech? So I don't really see how this would enhance European sovereignty, because it's basically a gift for big American technology companies.
Thank you.
One last very fast question, microphone 3.
Okay. Have you noticed that the German DPA has been working with Axel Voss' office on changes on the GDPR, arguing for more data flows? So please consider the German DPA as an enemy of GDPR.
Yeah, for those of you who don't know, there's an expert group set up by some think tank in Germany, which includes the German Federal Commissioner, Max Schrems, the assistant of Axel Voss, a couple of other people, some good, some rather questionable. And I think they've already come up with like 4 proposals for changing the GDPR, which are like completely
outside of this,
detached from the Commission proposals. But Max Schrems has already told me that he left this group and he asked them to take his name off because the proposals are bad. But I would not overestimate the impact of that. It's really nobody cares about German think tank doing something. Stuff happens in Brussels.
I think that there's an important takeaway from this, which is that there are already cracks in the EPP, so even the Conservatives are not completely behind this proposal.
Yeah.
And then the second thing is that we need to have a strategic clarity on, yes, the GDPR would need meaningful reforms, and there are things that we should change here, but yeah, the problem is like, Where do we do this? In this current climate, renegotiating these things might not lead to a better outcome. So we need to be very realistic with our ability to achieve an outcome we would fight for, because if you open something up, it will be renegotiated by the powers at play. And that's right now not us in the majority.
Yeah, so when I said we are trying to get the rapporteur job again, to become the chief negotiator, this time it would be our pirate Marketa Gregorova. This is not that because we think we could make a big improvement and celebrate it as a big win for European citizens. No, it's just to maximize damage control, and to keep the calendar under our control and stuff like that, to make sure we get an impact assessment at least, That's where we are. And anything else we want to achieve in terms of improving, we can only do this with help from outside the parliament and outside of Brussels, which is you.
And that's a good word for finishing. Thank you very much to the two of you for this great talk.